Hi small business owners, it's Harpreet Singh from Sharon Law Firm. Today in the series of videos discussing about commercial lease and different topics related to it, today I want to talk about leasehold improvements and the ownership of the equipment after the lease get expired. So suppose you are a small business owner running a convenience store and you are just left with a couple of months of your lease and you have installed a walk-in cooler and other shelves on the wall and also some other important equipment which is attached to the wall or attached to the windows, and now you are thinking, okay, means I need to remove these items, but you are concerned about the ownership of those items, and you just contact the landlord, and landlord is now disputing about these ownership of these items, and now you have a legal dispute. So how to resolve it? So the first source you have to look is your lease, because that's the most important source, because a contract out item which provides a specific ownership to a particular party just will govern rather than a default rule provided by the law. So first you have to look your commercial lease and just read a clause which mentions about leasehold improvements or any kind of equipment ownership which is gained during the lease or which is provided after the lease is ended. So I think if your lease is well drafted, then you would not having any kind of issues. But however, most of the time the lease is not well drafted, or there is a clause but it doesn't provide you much info. It's a very generalized clause which mention, okay, any and all leasehold improvement will go to the landlord and tenant will not retain any ownership in it, and you are confused. So in such a situation, what you do? So the courts handle such a situation through default rules. So any kind of item you are installing during your lease time, or does it become the part of real estate or not? So these items are called fixture if it becomes the part of real estate. And how you know if it becomes the part of real estate? It depends on multiple factors. So the court will look how this item is attached, and while the tenant attaching these items to the real estate, what was the intent of the tenant and what kind of item it is. If we are talking about some kind of equipment which you just installed because of your business operation and you have intent to remove it, and what conversation the parties have during the installation of this kind of equipment, and also while removal of this equipment, what happens with the real estate. So all these factors the court will take into consideration to think about, does it becomes the part of real estate and then it ultimately goes to the landlord or not. But there is also another rule which is a default rule which is provided by California Civil Code. If you have installed this piece of equipment for your own business, trade, or for manufacturing purposes, then you can remove this piece of equipment as your own property during the time of your lease, once you are still in possession, without making major damage to the landlord's property. So you have to make sure, if you are removing any kind of equipment which you have installed during the time of your tenancy, then you have to make sure that this piece of equipment should not damage the property significantly, because some of the piece of equipment which is attached to the structure of the building, and if you remove them, it will just, there is a great fear about the damage to the structure of the building. Then there is a big question about such an equipment, and then you have to unfortunately go into further litigation, and then court have to look these different factors to decide about the ownership of that item. But if it's an item which is you can easily remove it, and it just puts maybe like one patch to the wall, maybe some little bit of holes in it which you can just easily patch. So I think that would not provide you any kind of problem. But the important thing is that you have to remove this item which you have installed during your tenancy once you are in possession, because if you hand over the possession to the landlord and you have not removed these items, then you have hard time to enforce any kind of possession right on that item unless and until your lease provides any kind of provision which provides the ownership to you. So first, your lease will govern about the ownership of the item, and if your lease doesn't provide any definition or any way to identify the ownership, then sure, you have to go through the default rule. But it's always good to manage your expectation and present your expectation in your lease instead of relying on a default rule which may not be based on your expectation, and you may lose the ownership of this suppose walk-in cooler which is around $15,000-$20,000. So you have to lose a significant piece of item. So always read your lease before you are signing it, so you can make sure which items are coming with you and which items are not. So again, don't follow this video to address your legal issues on your own. Just see a legal professional for any kind of legal issues. And sure, if you want us to review your lease, we would be happy to do that and just provide your rights and obligations under the lease. And always work on your business, work hard, and just give us any legal worries you have, and we will see if we can able to help you out on that. And just look for the next video about other real estate topics which I'm anticipating to bring, and so you can just get some general legal information. And if you have any legal issues, always we are there for you. And thank you for looking these videos. Thank you.